Good afternoon and welcome to this, which is going to be part 2 of a 4-part Trump administration webinar series. This one is going to cover basically immigration options and planning, kind of Trump administration unknowns, enforcement environment, options for employers and employees, and some information about kind of planning techniques to ensure compliance with immigration laws and regulations. I mentioned this was the second part. In case you missed part 1, have no fear. You can actually still find it through our website. Basically, the first one went through more kind of focus on FDNS site visits, H-1B, public access files, labor condition application, which we're going to go over a little bit today as well. But in case you missed that one's available there. The other 2 parts, part 3 and part 4. Part 3 is actually going to be tomorrow, and that is going to focus very much in on I-9 compliance and kind of where we see that going with the new administration. Part 4 will actually be next week, Wednesday, January 25th, and that will kind of go more into considerations for those with criminal convictions, DUIs, removal proceedings, that side of things, and how that's likely to change. So please sign up for those if you haven't already today. So first thing, our firm, this is Wolfsdorf Rosendahl LLP. We have 20 lawyers. We offer full service global immigration mobility services. Our offices are in Santa Monica and New York. I'm currently speaking from Santa Monica, California. We're also a member of ABLE, which is the Global Alliance of Business Immigration Lawyers, with 35 immigration law firms across the world providing high standard of care and legal. We operate in 40 gateway cities throughout the world, and this ABLE allows us to offer full immigration services in over 100 countries. After that plug, let's get straight into the Trump manifesto. So what do we know at this point? The 3 main areas that Trump has mentioned in terms of where he wants to go with immigration plan, basically the focus has been on these 3 main areas. One is prioritizing the jobs, wages, and security of the American people. 2 is establishing new immigration controls to boost wages and to ensure that open jobs are offered to American workers first. The 3rd one is this protects the economic well-being of lawful immigrants by curbing uncontrolled foreign worker admissions. It's a little bit vague, but as a lot of the things have been so far, that's what we've got. So I want to kind of explore each one of these in a little bit more detail. The first one is going to be looking at this kind of prioritizing the jobs, wages, and particularly the security of the American people. Now, one of the main campaign promises, one of the main things that he's talked about constantly was this impenetrable wall, or then it turned into maybe a fence, and now it seems to be back to being a wall again. This 2,000-mile border wall, who we're not sure who's going to be pay or reimbursed for, this is going to be obviously one of the key things that he's looking at doing, and this would be kind of a focus of the security side of things, securing the American people, this area. Another area that it looks like he's going to kind of focus in on is going to be suspending issuance of visas in countries where sufficient screening cannot occur. The idea here is being, those countries that are compromised by terrorism, people foreign nationals from those countries may no longer be able to get visas issued there. So this could really affect a lot of people. The issue, I guess, here is also kind of which countries would you say have been compromised by terrorism? Does this count any countries that have had a terrorist attack? In which case, are we looking at France, Germany, and the United Kingdom at this point? Or are we just looking at more so where countries where there's certain screening or increased document fraud or something along those lines? So this is somewhat up in the air and definitely a bit of an unknown at this point. The other one is extreme vetting. This suggests maybe some kind of resurrection of the post 9/11 special registration. which was requiring kind of additional screening of entry and exit requirements for travelers from certain countries, whether this be for travelers that have visited certain countries or are of particular religious backgrounds. This side of things is not entirely sure yet. Clearly there have been things that he said that suggest that this may be more of a religious side of things, but again, not something we really have much clarity on yet. The second aspect of this is obviously establishing new immigration controls to protect US workers. Now, in this regard, I want to go into a couple of different areas in terms of things that he said about different work visas, different kind of options that exist currently for immigrants. The first one I want to cover is the H-1B program. Now, Trump did say he wants to end forever the use of the H-1B as a cheap labor program, instituting an absolute requirement to hire American workers first for every visa and immigration program, no exceptions. Now, strangely, Trump has potentially contradicted himself a little on this, talking about how we need the highly skilled workers, we need to keep the brain power in this country. So it can seem contradictory because the H-1B is basically the main professional work visa. I mean, to get an H-1B, the position itself has to require the minimum of at least a bachelor's degree to do those jobs. So these are pretty much high-skilled positions. There's a special carve-out of 20,000 visas for those with a U.S. master's degree. And it's honestly, it's become kind of one of the main working visas that particularly students who, you know, go from school, get OPT, and then transfer to an H-1B with an employer. It's one of the main working visas that people use, and it's massively oversubscribed. I mentioned that there's 85,000 visas available each fiscal year. Last year, we saw something around 230,000 applications for those 85,000 visas. The way immigration handles that currently is they put all 230,000 into a lottery, and that lottery then determines which ones they're actually going to look at, which ones they're actually going to adjudicate, and which they're just going to send back and say, you know, bad luck, you weren't selected. So clearly this is something that US employers have been wanting to have, there's demand for. You know, there's obviously demand for these H-1B visas. We don't know what he's going to do on this side of things. You know, there's been a lot of talk, a lot of different ideas, a lot of speculation. A few key areas that people have kind of focused in on, and you know, it suggests that there may be changes or reform to the H-1B program. One would be this kind of area of increasing minimum wages. With the H-1B, there's a prevailing wage requirement that individual has to be paid the prevailing wage for the particular position, the particular job in that particular geographical location. And this is all set up by Department of Labor. It changes every year. It often seems to be quite a lot higher than sometimes what we're necessarily seeing on the ground, but this is one of the kind of things that actually exists right now to make sure that US workers coming in under the H-1B program are not undercutting US workers. The suggestion here is to increase that threshold, increase it to something like, let's say, 110,000. Now that's going to cut off a lot of the positions where people are coming in, obviously at a lower salary, they would no longer be eligible. Another reform that people have mentioned, have talked about, is adding some kind of recruitment, like perm green cards. Now currently perm green cards, the way they work is there's a Department of Labor. First off, in terms of actually being able to get a green card, the employer has to recruit for that position. They have to do a test of the labor market. They have to recruit for that position and show there's no qualified US workers for that particular position. Once they've done that and they ensure that there are no US qualified US workers, then they can move forward with getting the green card. Suggestion that maybe the H-1B will go a similar route. Maybe we'll actually include some kind of recruitment process, some kind of test of the labor market. That's going to very much increase the burden on employers that may want to hire workers from outside the country through the H-1B program, because currently that's not a requirement. Currently the prevailing wage pretty much stops them from undercutting, but if they had to recruit for the position and show no qualified US workers, this could make it a lot tougher to get an employer who's willing to sponsor for an H-1B. One of the other reforms that people have mentioned and that could be in the offing would be replacing the lottery that I mentioned with a system where instead companies that pay the highest wages obtain the H-1B quota numbers. So this would basically look, right now, and this is a question we get all the time, when people are filing and they're like, oh, is there anything that we can do with our H-1B to, make it increase the chances that it's going to get selected in the lottery? And it basically the case is no. I mean, right now, everything goes into this lottery. Some of the very weak case has just as much chance of being selected as a very strong case. Someone who is just being made the prevailing wage has just about as much chance of being selected in the lottery as someone who's earning 200, 300,000 under the H-1B. So this could be something that instead of going through that lottery side of things, I mean, they would basically look instead at who's earning the most, where's the salary. Of course, this raises another issue because every employer may then want to list super high wages, and then once they get the H-1B, try and reduce it. Obviously, that's not going to work because the H-1B program is very heavily scrutinized right now. There's the Fraud Detection Nationality Service, which will actually come out and perform site visits to make sure that the employee is really being paid whatever the prevailing wage, whatever the wage that was listed in the petition was. So these kind of things are not going to be an option. But again, this is another option that people have discussed. Another area would be to ban outsourcing companies from the H-1B program. This would be companies where they kind of your traditional job shop almost, where a company, let's say, sponsors 50 people, and once they get those H's, the idea is that they then outsource them. They kind of give those jobs to other employers that need them. And this would be another possible reform that could be in the mix. The next visa type I wanted to discuss was the TN. Now, Trump has said very clearly that he wants to renegotiate NAFTA, which he described as probably the worst trade deal ever agreed to, and has actually said, that if we don't get the deal we want, we will withdraw from NAFTA, start all over, and get a much, much better deal. Now, this is a treaty. If it were, I think basically the treaty requires about 6 months worth of notice if the US is going to withdraw from it. How does this impact the TN? Well, the TN is basically a treaty NAFTA visa. It actually exists because of the NAFTA treaty. If there's no NAFTA, then there's no TN visa. However, they do appear, the Trump transition team does appear to be backpedaling a little bit on this. They have mentioned, not wanting to rip up NAFTA, more looking to try and amend it, change it. So hopefully this is a good sign that the TN is not going to be going anywhere anytime soon. The TN, for people that don't know about it, is basically a visa for professionals from Canada and Mexico. Certain occupational categories, such as graphic designer, these kind of engineer, these kind of positions that it's a little bit easier for a Canadian or a Mexican to be able to get a TN visa to allow them to come into the US and to work under this category. Probably in terms of leaving NAFTA, there would actually be probably more substantial trade implications to the US that Trump may not quite have considered so far. This, again, as I mentioned, really kind of makes us think that this is probably unlikely that they're actually going to withdraw from it. But in the worst case scenario, if they were to, you would basically be looking at the TN visa no longer existing, those who are currently on TN losing their work authorization and going from there. So Trump versus other non-immigrants. STEM OPT. Now, STEM OPT has been extended and expanded quite a bit over the past administrations. Obama actually recently extended STEM OPT from 17 to 24 months. What it is for certain degrees, it allows them, following the degree, if it's a STEM degree, from actually being able to have a longer period of time where they're able to be employed. They get an OPT, which is basically an employment authorization card for that extended period of time so that they can work in their field. And one of the great things about STEM OPT, because of the extension, gives you more chance, gives those people more chance to apply under the H-1B lottery. And more chances means more probability of success, and therefore more likely to get an H-1B and go from there onwards towards green cards. So STEM OPT, is it going to go anywhere? We're really not sure. I mean, there's definitely some groups out there that feel that STEM OPT is wrong. It's not driving the economy. It's not actually kind of benefiting the United States. And some of those groups are the same groups that have supported Trump at various times. So this is something, again, one of those unknowns. We're really not sure what's going to happen with that. At this point, it doesn't seem like it's going anywhere. It actually, the new extension of STEM OPT has a lot of provisions in it, which kind of somewhat restrict it and kind of, particularly like we'll go into a little bit later, E-Verify, requiring that the employers are E-Verify registered. So in effect, STEM OPT is almost a way to increase compliance, increase that side of things. So we don't necessarily see that going anywhere anytime soon. O1, E2, these are just other visas. I mean, the E2 is an investor treaty visa. If Trump were to fall out with a country, it is possible that maybe as a result of that, the treaty, he backs out of the treaty or tries to go along those kind of ways, which could lead to issues with the E2. The E2 is basically a series of treaties between the US and other countries that allows nationals of that country to enter the United States to invest, to create their own company, to hire US workers and this kind of thing. It's unlikely, it seems unlikely from a job creator president that he would necessarily kind of go against the E2. However, it's possible, and it's also possible that with all of these things, if there's an increase in, kind of anti-immigrant feeling, that maybe officers begin to be a little bit tougher. The increased enforcement, increased scrutiny of petitions, of applications at the embassy level, and this can have a knock-on effect on these kind of categories. Similar with the O1, the O1 is a visa for those with extraordinary ability, extraordinary achievement in their particular field, massively used, by artists, by entertainers, by directors, producers, the film industry here in the United States. Again, it's one of those categories that could face additional scrutiny. We've seen it happen in the past with certain categories, such as the L1B, which is a visa category for intercompany transfers of specialized knowledge individuals. The adjudication has very much got very, very tough, a lot tougher. And it is possible that, again, with a new administration, kind of more increased scrutiny, particularly with the Attorney General Sessions, who is somewhat anti-immigration, that these, it could get worse on these fronts. The age for spousal work authorization. Now, this is something that Obama kind of added to currently exists for a very limited number of H4 spouses. These are the spouses of H1B visa holders, and it exists in certain situations where a company has filed a certain stage of a green card for that individual. It allows the spouse to actually work in certain situations. Now, again, like I said with the STEM OPT, there have been groups that are against this, do not want this kind of increased number of people suddenly able to work in any positions. And some of those groups are people that have supported Trump, so maybe this is something that could be amended or dialed back somewhat. Trump versus green card. Now, green card applicants particularly. Now, Trump is known to be kind of a real estate guy. And when you look at the EB-5 program, this is investment green cards. This is where currently you invest 500,000 or $1 million and you get a green card. The EB-5 is very much an employment creation program. It's very much not just based on the investment that you have to invest, and that investment has to create employment. It has to create a certain number of jobs, sometimes indirect, sometimes direct. So that side of things would suggest that Trump would be on board with this, with the EB-5 program, may even be a fan of it. I believe his son-in-law has taken EB-5 investments from Chinese investments in the past, and as a self-professed job-created president, it would seem like this would be a category that he may want to extend. A lot of the EB-5 program has been through Chinese investors, and obviously he has seemed to have taken quite a tough stance on China so far. But then again, on the other side, this is money coming out of China and being invested in the United States in setting up things. So it may be that this is just the kind of program that he wants to encourage and expand even. As for national interest waiver, EB2, EB3, these are basically green card sponsored options, except for the NIW, which is more of, where you're actually being able to show that your presence in the United States is in the national interest of the United States. So you would think that the national interest waiver would be something that he would still be positive towards. EB2 and EB3, in terms of perm-based green cards, this is where, as I mentioned earlier, you have your labor certification through the Department of Labor and have to recruit for the positions. These are already pretty tough. But again, this is an area where adjudication trends could get tougher. It's already tough, it's already strict, but if there's a kind of a feeling of, let's increase scrutiny of these cases, let's make sure, that you could see more audits in the perm process in the Department of Labor or labor certification process, which could add months, maybe even years in some cases, to some of the processing time. So this is something that, again, we're not really sure of. We don't really know exactly what is going to happen on that front. And of course, with all of this, there is always the chance that there is going to be some kind of actual immigration reform that will actually pass through Congress. If that were to happen, then everything could change at that point. So it's definitely something to watch out for. Diversity visa lottery, this is one that basically gives green cards to countries on a basis that, there's not a huge number of foreign nationals from that country immigrating to the United States. This could be something that he could take visas from and maybe put towards some of the other categories, such as EB-5, EB-2, EB-3. Family-based green cards, we don't really see that side of things changing, but at various times he's talked about stopping immigration until we figure things out. So in that case, maybe that's something that could be an issue down the line. Again, more unknowns, more things that we're really not sure about just yet. The third section that he mentioned is this curbing uncontrolled foreign worker admissions. Now, the key one of these is for the Dreamers. These are the recipients of the Deferred Action for Childhood Arrivals, or DACA. This was basically an executive action by President Obama in 2012. I think about 700,000 people have come out of the shadows, have applied, have got their employment authorization cards, are working here pursuant to this executive action. This is basically an action for those who entered the United States when they were under 16, so it wasn't kind of necessarily up to them at that point. They entered, they have been here for a set amount of time, they meet certain discretionary factors, such as no significant criminal issues, this kind of thing. The issue with this is that it is just an executive action. And Trump has talked in the past about kind of getting rid of these illegal kind of executive actions of the Obama administration. So this could be something that, without too much difficulty, Trump could rescind or take back. The problem is this would seem to be a very politically kind of just not a very good idea. The deferred action for childhood arrivals, the DACA kids, are really some of the best people in terms of when it comes to being able to mobilize, being able to kind of get social media on board and really kind of campaign and protest against this kind of action. And they're also people that really came here, wasn't their fault. They've worked, they've done extraordinary things in a lot of cases, and they're really probably not going to be the type of people that you'd really want Trump to be going after on this side of things. So it's hard to say. It's possible that he could slowly phase this out, or just end it. The problem here would be that companies who have hired individuals who are basically here based on deferred action, based on DACA, at some point, if he slowly phases out, says no more renewals, for example, once those employment authorization cards are done, that person is no longer able to work. So this would definitely be a major issue. The deferred action for parents of Americans and lawful permanent residents, this never actually happened. We were very close. The Texas federal court stopped this from actually going into effect. This would have helped potentially 4 million people who are in the United States, but this didn't actually happen. And we don't necessarily see this being something that's going to happen under a Trump administration. The one other area is this prosecutorial discretion. Under Obama, there was a great deal of prosecutorial discretion in situations where a foreign national who was here had a U.S. citizen anchor relative. A lot of times the immigration courts were allowing prosecutorial discretion and allowing administrative closure of their immigration proceedings or termination. Again, because this memo was basically an executive action, this could be something that is massively scaled back under a Trump administration. Particularly with regard to anyone with criminal convictions. Right now, immigration courts are massively overwhelmed. There's a lot of people in removal proceedings that are going through removal proceedings. Trump has made it very clear that he wants to focus in on those with criminal convictions, and really trying to kind of get on top of that side of things. Sanctuary cities, this is pretty much where a city is refusing to share information with the federal government in terms of kind of moving forward with removal proceedings. This, the Fed can basically withhold funding to force cooperation. So this could cause conflicts between certain cities, certain jurisdictions that kind of are unwilling to share and unwilling to work with Trump on this side of things. E-Verify is a federal program. This has been growing quite a lot over time. In some states, it's actually mandatory. It's mandatory generally with federal contractors. This is similar to it basically is involved in the employer compliance side of things. So typically when an employer brings on a new employee, they have to fill out an I-9. E-Verify allows them to enter that information directly into a system that will then give a tentative non-confirmation if this person is not authorized to work. This E-Verify system has continually been expanding. I mentioned earlier STEM OPT. STEM OPT is kind of one of those ways that they've been extending the reach of E-Verify. Right now it's a voluntary program for most employers, so it's slowly kind of becoming the norm. And I think that's definitely one of those things that appears to be to keep moving. The idea is that if there is any kind of immigration reform, they're also going to increase on enforcement side of things, which would be E-Verify and this area. For more information on this area, definitely already said, but it's worth signing up for our I-9 webinar tomorrow, because this will also go into E-Verify and that side of things. Refugees, obviously Piers Trump wants to reduce the number of refugees coming in. Extreme hardship standard, this is for those who have some kind of overstay or something like that, that there's certain waivers available. And currently the extreme hardship standard is a pretty tough standard to get past. You do have to show that if you were unable to stay in the United States, your anchor relative, your foreign, that side of things would really be subject to hardship over and above that which would normally be, kind of be the case of separation. So it is possible that new guidance could come out to make this even tougher. Provisional waivers, this is where basically someone is allowed to apply for an extreme hardship waiver while still in the United States. This is, from my perspective, this appears to be a really good idea. Kind of one of those few win-win situations, because it allows someone to apply for it while they're still in the United States, get a decision on it, and then if it's approved, they go abroad, they get their immigrant visa, they have the approved waiver, they come back in, they get their green card, and everything's good. This is one of those kind of measures that encourages people to come out of the shadows and means that people that are qualify for this are probably more likely to go do it than, if the requirement was, you have to leave the country, trigger a bar to be able to come back in, and then apply for a waiver and hope you get approved, because otherwise you're not coming back. So switching tack slightly onto enforcement environment, we really don't know how the immigration programs are going to be reformed specifically, but we know that there's going to be a focus on compliance and enforcement actions. We live in a regulated environment. We have to make sure that you learn the law, that you know exactly who you're hiring, what you have to do, because compliance is going to be key. And there are going to be the extra site visits with potential monetary or criminal penalties down the line. The one aspect of this is labor condition applications. This is the LCAs that are provided for on H-1B visa petitions, this side of things, which require the employer pays the required wage rate. This is going to be a continuing requirement, so it's very, very important to focus in on making sure that you stay in compliance with these actions. The LCA attestations are going to be very important as well. Right now, H-1Bs get the same working conditions as US employers, which includes hours, shifts, vacation periods. And this side of things you need to make sure, employers and employees need to make sure we're always in compliance with these things, especially with a potential increase in site visits and audits, or even potentially requests for evidence on extension petitions. Some additional requirements: you do have to provide a certified LCA to the H-1B worker, and there can be special requirements if an employer is hiring too many H-1B workers. This can definitely be an issue down the line as well. The public disclosure file. This is what you need to keep in a file. It's not part of an employment file, and it should be stored separately from the employment file. But this is, again, for H-1B employees. You must It must be available for public examination within 1 working day after submitting the LCA, must be maintained for 1 year beyond the last date the employee was employed under the LCA, and has to contain your original signed and certified LCA, a memo talking about what the actual wage is for similarly situated employees, prevailing wage source documentation, evidence of satisfying notice requirements, such as if a union is involved, you use your union notification, summary of benefits, change in corporate structure, H-1B dependency requirements. These are all things that you really need to be focusing on. Non-public documents, these records should be kept in a separate non-public file in case of site visit investigation. These are things like payroll records for the H-1B, a copy of the H-1B petition with the supporting documentation, memos confirming the employer provided a signed and certified LCA, and this file should also be very separate from the employment file. Consequences of non-compliance. Civil money penalties have maximums ranging from $1,000 to $35,000 per violation. This depends very much on the type and severity of the violation. Other consequences can include liability for paying back wages and debarment from future access to the H-1B program for a number of years. Some can even rise to the level of criminal sanctions. As I discussed, USCIS Fraud Detection and National Security, the FDNS, the workplace site visits are likely to increase. Site visits randomly occur on H-1B and L-1 petitions after adjudication, and R-1 petitions sometimes before adjudication. There are triggers such as if there's a extension filed, something along those lines. But these visits are unannounced visits to collect information as part of a compliance review. This is where they're going to come out. They're going to want to make sure that they can verify that what was filed in the petition was truthful and accurate. This is going to be something, participating in this is voluntary, but failure to cooperate can lead to issues on the compliance review, can lead to revocations of the petition, this kind of thing. At any point, if you're unwilling to participate, the inspector will terminate the visit, complete the report using the data that's available. The compliance review will then include a follow-up, which kind of really goes through either by phone, by fax, or by email, which actually kind of outlines exactly what that officer wants to see in terms of additional documentation. Our advice on this would always be, do not respond without first consulting counsel. The inspectors, that when they come out, they basically perform the following tasks. They're looking to verify the information, the supporting documents, what was submitted with the petition earlier, verify that the petitioning organization exists, and in the same way that was outlined in the petition. They like to review the public records and information on the petitioner, conducting unannounced site visits, taking photos, interviewing personnel, interviewing the beneficiary, confirming where the beneficiary works, physical workspace, hours, salary and duties, this kind of thing. And they will request additional documentation, such as payroll records, to make sure that this individual is being paid the prevailing wage for that position. Planning techniques. These are techniques that can ensure compliance. So if you have H-1B employees, if you have foreign national employees that are on different visas, you want to make sure you're prepared, and you want to make sure you have a strategy. Here are a few points. One of the main ones is to always make sure you designate in advance which employer representative will handle site visits. This means that as soon as an officer appears, you can refer them straight across to an employer representative who is able to effectively answer any questions and knows exactly what they can and can't do. The other side of things is to inform other staff members that they are not authorized and should refer these investigators to the responsible person. You don't want someone who has literally just started with the company being questioned on an employee that they may not even know yet or have an idea of. We've seen that in many cases where potentially a new receptionist has been hired and is asked about an employee, and they just they've never worked with that person before, so they're like, oh, I've never heard of that person. And this can then be a basis for further review, further issues down the line. The employer representative should be familiar with the content of the petitions and have easy access to them so they can verify all the information and stay kind of one step ahead of the officer and make sure everything is good. They should provide the beneficiary with a copy of the petition so that you can have them review typical questions that they're going to be asked. Again, key here is to make sure that everything in the petition is accurate and correct, so that when or if there is a site visit down the line, it's not something that's going to cause any issues. You should always check the officer's credentials and make sure you document them. Always accompany the officer while on site, especially if they want to take a tour or photo, just so that you can make sure that you know exactly where they went, what they saw, and can kind of put together a report or contest findings if they come back to you with a notice of revocation. And this also comes down to taking detailed notes of the visit, making sure that you go through any questions that were answered and any documentation that was submitted. Don't answer questions unless you're sure of the answers. It's best if you simply inform the officer. If you don't know the answer, just inform the officer that you will need to check on the information first. To give you an idea of the types of questions that they ask, these are things about the petitioner, which can include type of business, revenues, number of employees, locations. Questions about the petition itself, which would be things like position title, duties, salary, work location, job requirements, hours per week, payment of petitions fees. These are things that sometimes they'll have a checklist and that's been taken from the petition that lists the job duties, and they'll want to go through and make sure that the foreign national is doing each and every one of these job duties as was listed. If it's an L1, which is an intercompany transfer visa, they're going to ask about the management functions or the specialized knowledge. Other questions they can ask would be more related to the beneficiary, confirming that the person is actually working there, is continuing to work there, they have the qualifications that were listed in the petition, and an idea of kind of when their hire date was. And that's all I've got time for today. Thank you so much for joining us today, and as I mentioned earlier, please make sure to sign up for part 3, which will be with Bernard Wolfsdorf tomorrow at 11 a.m. Pacific time, which will really go through the I-9 process and the impact that we can see Trump having on that side of things. And then part 4, which will be next Wednesday, which will focus more in on immigration consequences of criminal convictions. Thanks again, and have a good day.